Article 10 of the FCM Treaty as a means of dispute settlement. Therefore, it violated the principle of pacta sunt servanda and also violated the Article 10 of the FCM Treaty. The second main argument also has a procedural value. Your Excellencies, we submit that all procedural rules were observed, since all the rules for the appointment of the arbitrators were duly applied. Article 10A of the FCM Treaty states how the appointment of the arbitrators should occur. After 60 days, if less than 3 arbitrators have been named, the ICJ's president shall appoint the remaining arbitrators. That is exactly what happened. On 28 February 2016, 60 days after the submission of Rukuruku, Judge Bacal, the president of ICJ, appointed the remaining arbitrators, as stated in the Statement of Agreed Facts, paragraph 22. Thus, the rules stated by the FCM Treaty were respected.
Counsel, is it a common practice for a judge to self-appoint him or herself?
Yes, it is. According to an analysis of the arbitral good practice, self-appointment does not categorize a bad practice or a violation of any procedural rules of arbitration. In our memorial, we have submitted a series of examples to illustrate that self-appointment is not categorized as a bad practice. I refer the court to pages 3 and 4.
Counsel, but could there be questions regarding the interests of the parties, or maybe regarding the impartiality of the self-indication, self-appointment?
Judge Bacal is the president of this honorable court and must be impartial, independent, and ethical. Not only that, but good faith is presumed. In case of bad faith, the burden of proof relies on who alleges the bad faith. Okay. Onlutchenko was also permanently notified of all communications and materials during the whole arbitral procedure. Since the beginning, the arbitral tribunal informed that all the communications and materials would be transmitted to Onlutchenko. The arbitral tribunal also allowed equal time for the respondent to submit a response to Rukuruku's memorial and to comment on all procedural questions. But Onlutchenko never took such actions. The tribunal still gave Onlutchenko all the time and right to defend itself and to fully access the documents related to the arbitral procedure. But Onlutchenko decided to remain indifferent to the arbitration which it had previously consented. Therefore, Your Excellencies, it is already very clear that the award of 2nd of March 2017 is valid. But in addition, we submit an alternative argument to the court. Rukuruku considers that the arbitral award is valid even if some technical irregularities were highlighted by the Institute of Legal Studies of Arbitration, as stated in paragraphs 30 to 33 of the Statement of Agreed Facts. We firstly consider that the evidence found and put forward by USA are illegal for 3 main reasons. And here I'd like to explain the context. On 21st March 2017, USA released a report with 3 documents about the arbitration between Rukuruku and Onlutchenko. The first document was the script of 3 telephone calls between Judge Moyer and Mr. Chibu, the consul of Rukuruku. Your Excellencies, any arbitrary interference in telephone call is a violation to the right of no arbitrary interference in private life, recognized by numerous human rights charters. USA never showed any judicial order allowing it to do the telephone calls interferences, and consequently all the evidence are illegal and void. The second document was a timetable of workload undertaken during the arbitral procedure. The workload of Mr. Ohovindadi has no irregularities, since Mr. Ohovindadi was the legal assistant of the 3 judges of the arbitration.
And is it normal that Mr. Ovindari the arbitral tribunal's assistant, as a legal assistant, is it normal that he worked more hours than the arbitrators?
Since he was assisting 3 judges and helping Judge Bacal to draft the award, he worked a lot on research, which takes a lot of time, and also worked for more hours than comparing the judges. The third document is a cover draft of the award. Your Excellencies, the only way UniCEUB could have obtained the draft of the award would be through a leak, but the fundamental principle of arbitration is confidentiality. Revealing the award or other documents to the general public is a right which only the parties have and no one else. Leaking confidential documents is totally against the best practice reviewed by several conventions and arbitration model rules.
What is the legal value of these model rules which respondent puts forward here?
They are used and accepted and applied rules that have a customary value. The technical irregularities do not invalidate the award because there are no proof of corruption or that the arbitration was not independent and impartial. Therefore, Your Excellencies, we conclude that the award of 2nd of March 2017 is valid. I now leave the floor for my colleague, Maria Carolina, for the second claim.
Thank you, Counsel.
Good morning, Your Excellencies. May it please the Court, my name is Maria Carolina and I'm an agent for the Federal Republic of Vucu. Today I will be presenting the second claim submitted before this Court, and for that I will be speaking for 10 minutes. Firstly, we submit that Vucu did not violate Article 6 of the FCN Treaty when the Eggers operated in Andochenko's territorial sea. And lastly, that Andochenko violated Article 7 of the same treaty by capturing the Eggers. Starting the first issue, we shall highlight that both parties have as an obligation to respect the sovereign territory and sovereign waters of the other contracting party, under Article 6 of the FCN Treaty. Excellencies, the navigation of the Eggers through Andochenko's territorial sea should not be considered as a breach to Article 6, because it was nothing but an innocent passage. Article 17 of the Montego Bay Convention, that I will be referring as UNCLOS, ensures the right of innocent passage for all vessels through territorial seas. Article 19 of the same convention defines that an innocent passage as a passage that is not prejudicial to peace, security, and good order of a coastal state.
Counsel, is not a military vessel by its own nature a potential threat to peace and good order within the territory of another state?
The Eggers was not a military vessel. It was a vessel that was designed to collect data of all the Odessa region, and it was not armed. Your Excellency, at no time the data collected by the Eggers should be considered as a threat to Andochenko's peace, security, and good order, since Vucu shared all the information that was gathered with all the other nations in the Odessa region. The data was collected for the benefits and interests of all states, as declared in the Statement of Agreed Facts, paragraph 5. Excellency, we shall highlight again that the Eggers was not armed and had at its only purpose the collection of data to protect the Odessa region. The research undertaken by the Eggers cannot be considered as a violation of Article 19 of UNCLOS, since the Eggers was not a spy vessel. The Eggers was designed to help perpetuate the stability of the region by means of surveillance. In other words, Your Excellencies, the Eggers was a means to preserve peace, security, and good order. Moreover, we must consider that the Egert also enjoys the right of immunity. Article 32 of UNCLOS clarifies that nothing in the Convention affects the right of immunity of government ships operated for non-commercial purpose. Also, that's why Undechenka's maritime law cannot apply to the Egert because of its jurisdictional immunity. As an alternative, we must present that the maritime law adopted by Undechenka violates the principle of good faith, considering that it infringed the FCN Treaty. In the FCN Treaty preamble, the intention of enabling free...
Council, does not the FCN Treaty provide for commercial navigation, in which case the Egert will not fit within such type of navigation?
Your Excellency, the treaty assures that there should be free navigation and commerce between the countries, but it does not say that the navigation has its only purpose, commerce. So as well, the Egert should have free passage. As an alternative, we must present that the maritime law adopted by Undechenka violate the principle of good faith, considering that it infringed the FCN Treaty.
Consent? What is the value of the principle of good faith?
Sorry?
What is the value of this principle of good faith?
Excellency, since World War II, the Odessa region has been a hub for illicit arms trafficking and pirate attacks. Ruku has since then guaranteed the security of the whole Odessa region, and for that, good faith should be considered.
I was just asking the value in international law, if it's customary, convention, which source of international law is?
The respondent does not have an answer to your question. Since the adoption of FCN Treaty, Ruku's navy was free to navigate in Undechenka's waters, and never until August of 2010, when Undechenka's maritime security law was adopted, has been any complaint from Undechenka. But in 2010, within the maritime regulation imposing that vessels should have prior authorization of the government for entering Undechenka's waters, the FCN Treaty suffered from an unexpected interpretation. Undechenka acted with bad faith by adopting the maritime security law, since the obligation of prior authorizations enables Undechenka to generally and arbitrarily limit navigation in its waters. Excellencies, therefore, it is clear that Ruku did not violate Article 6 of the FCN Treaty when the Egert operated in Undechenka's territorial sea. Now, Your Excellencies, turning to the second part of the submission, we submit that Undechenka violated Article 7 of CN Treaty when capturing the Egert, and that must be therefore returned to Ruku. Excellencies, Article 7 of the FCN Treaty states that shall be freedom of commerce and navigation between the contracting parties. Firstly, it is relevant to highlight Article 2 of the UN Charter that asserts that the international community agrees that disputes should be settled in peaceful ways, on which states must adopt non-aggressive measures as a first means of dispute resolutions. At no time the Egert was required to leave. It was captured right away by Undechenka. We shall act...
Council, but could the Egert be required to leave, considering that it was an autonomous vehicle?
Even after the Egert was captured, when Undechenka realized that the Egert was from Ruku, it could easily reach the country. At no time the Egert was required to leave. It was captured right away by Undechenka. We shall emphasize that even when warships infringe maritime law, the first measure is not an immediate and radical capture of the vessel. It must be asked to leave before the problem to be solved, so the problem can be solved in a peaceful way, as stated in Article 31 of UNCLOS. Also, both nations intended to make navigation free between the neighboring nations, as stated in Article 7 of the FCN Treaty. After capturing the Egert, Undechenka disrespected the treaty since it did not allow the Egert to navigate freely. Thus, we conclude that Undechenka violated Article 7 of the FCN Treaty by capturing the Egert. Excellencies, if there is no further questions, I will leave the floor to my co-agent Nayara Lima, who will address the two last claims.
Thank you, Agent.
Mr. President, honorable member of this court, good morning. My name is Nayara Lima, and it's an honor for me to appear before this court today, pleading on behalf of the respondent for 12 minutes. The structure of my arguments regards Claim 3 and Claim 4. Claim 3 regards the illegality of applicants' actions by legality of the IBR toward the international law and the FCM treaty. The Claim 4 regards the legality of respondent actions by capturing the IBR and attacking the court. Turning now to Claim 3, Article 16 applies to states to comply with all disarmament obligations binding them under international law. Respondent argues that the obligation to nuclear disarm is part of a customary international law. Respondent sustains that the obligation to negotiation in nuclear disarmament is a disarmament obligation. This customary obligation was recognized by International Court of Justice in its advisory opinion on the nuclear weapons in 1996 in paragraph 12 of the disposition. It was recognized that there exists an obligation to pursue negotiations leading to nuclear disarmament.
But was this put as being a custom?
Your Excellency, it has not recognized as a custom yet, but we sustain here that it has always the first time to be recognized. And here we have the criteria defined in the continental shelf case by this court that has to fulfill to be a customary international law. And here, respondent sustains that it's perfectly applied to this case. If I may proceed, this court has already recognized in the continental shelf case that we have to have 3 conditions for a customary international law be recognized. First one, it needs to be a norm-creating character. Its provisions are formulated in a way that no other conditions are permitted. As we are treating here about nuclear weapons, the destructive power, as recognized by this court in its advisory opinion, cannot be contained in either space or time. Therefore, we cannot accept other conditions by making the disarmament of nuclear weapons, since the destructive power can eliminate humankind. The second condition is the very widespread and representative participation in the convention. Your Excellency, we actually have 191 states parties to the NPT, the Non-Proliferation Treaty, such as India, Pakistan, and Korea, that also have nuclear arms. The third condition is the virtually uniform practice as an evidence of opinion use. We have numerous efforts made toward nuclear disarmament at the UN high-level meeting and the 1978 special session of the General Assembly, where it was recognized the disarmament of nuclear weapons as the ultimate objective. In addition, the criteria of opinion use was discussed again in the Nicaragua case in paragraph 168. It's not expected that the practice of states about the application of the rule should be perfect in the sense that states should have refrained at all to the complete consistency. Those actions that are inconsistent should be considered as a breach of that law and not a new rule. Excellencies, the obligation was also recognized by Security Council Resolution 984 from 1995 and 187 from 2009, where the Security Council calls upon all states to...
Council, what is the legal value of these Security Council resolutions to which respondent refer?
When the Security Council adopts resolutions under Chapter 7 of the UN Charter, it binds on the parties, which is the case here, Your Excellencies. The states that are not parties to the Non-Proliferation Treaty to accede to the treaty as a non-nuclear weapon state to achieve its universality. It should not pass unnoticed that it is a general call upon all UN member states, whether or not parties to the NPT. Also, the fact that these resolutions receive support for a great number of states.
Even if the court accepts your argument and affirm that there is a customary principle, does it apply to the states in a whole case, or the state has some way, a way to avoid the application of the customary international law?
Respondents sustain that there is no way to avoid the application, since they signed a treaty that in Article 16 it provides that must respect all disarmament obligations binding on them under international law. Since the customary law has been recognized as the Excellency proposed, is binding on Lukashenko. Therefore, it has to comply with the disarmament obligation to disarm the nuclear weapons.
Would there be a legal means through which Andrushenko would not be obliged to comply?
Yes, Jackson, there is a third, that means persistent objector, which in the case does not apply. Since to be a persistent objector, Andrushenko should be complying, not complying with obligations since the formation of its group, which is not the case. Furthermore, applicants should bring to conclusion negotiations toward the non-proliferation and the disarmament of nuclear weapons. Instead, they engage in a program of improvements of its nuclear arsenal, what constitutes a vertical nuclear proliferation. Therefore, it fails to respect the obligation to disarm the nuclear weapons. Finally, this court has already confirmed in the Security Council 890 meeting in 1998 that the general and complete disarmament is the ultimate objective. Your Excellency, the facts here are clear, and they prove that the operation of the Hydra of a nuclear submarine does not constitute an action toward nuclear disarmament, and consequently violated the Article 16 by not respecting its obligation under international law. If there is no further questions, Your Excellency, respondents would like to submit Claim 4 about the legality of respondents' action against the COFID and the Hydra. We sustain that respondent is not in breach of Article 17 of the FCN because of three main arguments. Firstly, we had authorization to check the measures by the Security Council resolution. Secondly, we exercised our human rights to self-defense. And thirdly, one is that we respected our obligation stated by the Non-Proliferation Treaty to comply with nuclear disarmament. Turning on to the first, there was no violation because member states are authorized to take commensurate measures to deal with Hydra under international law. Your Excellency, Mukaruku acted under the Security Council Resolution 3790 with the goal to maintain peace in the Lazarus region. According to UN Charter in its Article 40, the Security Council is unable to impose measures which are legally binding on states. Therefore, Mukaruku's capture to the Hydra was authorized by this resolution 3789. In paragraph 4, it states that member states are authorized to take commensurate measures to deal with the specific circumstance with the Hydra to neutralize it. We can assure that the capture of the Hydra is a commensurate measure because of two main reasons. Firstly, the very presence of nuclear weapons is an imminent threat to the Lazarus region because of its potential destructive power.
Counsel, turning to the self-defense question, does an imminent threat justify an act of self-defense as per the UN Charter?
We should not only be restricted to the UN Charter Article 51, since in the international corridors it is recognized by the very widespread and accept Caroline case that has Caroline criteria, and here are fulfilled. Therefore, the imminent threat that we have here is one of the criteria of the Caroline case, which allows the self-defense.
Council, there are countries that do possess nuclear weapons, such as the United States, for example, and there is no imminent threat to their neighbors. So why in this case do you sustain that there is an imminent threat, even though there was no sign of aggression or any other similar situations?
The excellent respondent understand your concern. The applicant would like to quote the General Tobori statements about the presence of nuclear weapon in Lukashenko. Here in the statement of agreed facts, I quote paragraph 38, that General Tobori said, "It will serve as a firm deterrence against who would persist infringe our sovereignty." Therefore, since Lukashenko has the nuclear weapons on a boat in a submarine, like as it was in operating it,
it represents an imminent threat because it was not just a possession. They put on the high seas. Therefore, it was not just a possession. They would intend to use it.
Counsel, if the president of the United States, Donald Trump, publishes a tweet stating that he intends to attack North Korea, would we be in the same configuration, meaning that the other country, North Korea in this sense, would North Korea be entitled to act in self-defense?
Yes, Jackson, respondents sustain that anticipatory self-defense perfectly applies since there is an imminent threat. Therefore, if Donald Trump decided to attack Korea and post a message about it, it would be applied because there is an imminent threat. We are treating here about nuclear weapons, a mass destructive weapon. Therefore, it fulfills the criteria of the Caroline case.
Counsel, is this court bound by the Caroline case?
No, Your Excellency is not bound because the case here that are just not bound. But it demonstrates the concern of international community by accepting this case, and also the previously decisions of this case, which must be considered to take a decision here. Moreover, Your Excellencies, if the expected attack is one of a massive scale, as we have here the use of nuclear weapons, the victim state cannot be expected to restrict its anticipatory self-defense only to frustrate the imminent attack alone. It may act to remove the wider threat, as we did by attacking the cockpit, as we regret the loss of lives. Furthermore, Your Excellency, by attacking the cockpit and capturing the Ibra, we were respecting. I see that my time has lapsed. I refer the card to the memorial for Venezuela.
You have 30 seconds if you want to conclude on this law submission.
Thank you, Your Excellency. We were respecting our obligation, the Non-Proliferation Treaty, by complying to achieve nuclear disarmament. Therefore, our actions against the conflict and the Ibra was with the goal to maintain the peace in the Sahel region. Thank you, Your Excellency.
Thank you. The parties will have 3 minutes for rebuttal et à répliquer après réplique. The floor is left to Nitish.
Good morning, Your Excellencies. Applicant would like to refer the rebuttal in 3 main points. First, Your Excellencies, we would like to sustain that Article 10 of the FCN Treaty is not a consent clause. Therefore, Underchinka did not give its consent to the previous arbitration. Your Excellencies, Article 10 of the FCN Treaty only provides for arbitration, and consent must be given in a case-by-case basis. Therefore, we sustain that the award of 2 March 2017 is invalid. Your Excellencies, moving to my second point, the eager that was navigating in Underchinka's territorial sea is not acting as innocent passage. Your Excellencies, the eager was a spy vessel. Therefore, the collection of data cannot be framed as innocent passage because it is indeed prejudicial passage according to Article 19(2)(c) of the Montego Bay Convention, since it is the collection of data to the prejudice of the security of a state. Your Excellencies, turning now to applicant's last point, we would like to sustain that the non-proliferation of weapons or the possession of nuclear weapons, the non-possession of nuclear weapons, it is not a norm of customary international law, as stated by this court in the advisory opinion on the legality of the threat or use of nuclear weapons, paragraph 67, 72, and 74, it stated clearly that there was no customary rule that can show that there is no permission for the use of a nuclear weapon, and was not even able to find in a corroborating opinion yours. Therefore, we sustain that applicant has its sovereign right to possess a nuclear weapon, since it does not have any legal or customary source which is bound to comply. Your Excellencies, those were the 3 points that applicant would like to rebuttal. Thank you.
Thank you, Counsel. Respondent has the floor.
Your Excellencies, respondent would like to sustain that however, the FCN Treaty does not, in Article 10, has the expressive words and means consent That was the procedures of the arbitral tribunal. Therefore, Andushenko consented to the procedures to be applied. The second point, it was an innocent passage since Hukaruku has the custom to collect the data of the regions and share to the others. The third point, the non-proliferation treaty is a customary international law. Since we have here the criteria recognized by this court previously in the continental shelf case, and we demonstrated before that all the criteria apply to the present case. Those was the argument respondent would like to sustain. Thank you.
Thank you, counsellors. Thank you to all. Maybe first of all, a clap of hands for that. Eu vou voltar a falar em português. O fato de falar em inglês deixa, como vocês podem ver, as pessoas um pouco mais bravas. O que acontece normalmente a este momento é que não vai acontecer hoje. O público se retira para que o tribunal possa deliberar e decidir quem venceu. Então, como apenas uma simulação não é algo que faremos hoje, eu gostaria de apresentar o tribunal para vocês, começando pela esquerda, a Jacqueline, que é uma mestranda nossa aqui, cuja dissertação versa sobre os refugiados. E à minha direita, o professor Julien Delou, que é o nosso mais novo professor associado ao mestrado, programa de mestrado e doutorado aqui. O Julien é francês, ele defendeu a tese de Direito Internacional Ambiental na Universidade Aix-Marseille em dezembro do ano passado. Então vocês vão vê-lo por aí nos corredores durante os próximos meses, certo? Então, esse tipo de exercício que queríamos mostrar para vocês, até para incentivá-los a participar dos futuros processos seletivos, é algo que também se faz dentro do grupo de pesquisa que eu coordeno. É uma atividade que eu faço como a minha prova final na aula de Direito Internacional Público. E no tempo que temos, eu gostaria de escutar se vocês têm dúvidas, perguntas, não necessariamente para nós aqui, mas talvez sobretudo para os seus colegas. Se alguém tiver uma dúvida, é o momento para perguntar. Não sei se os membros do tribunal querem acrescentar algo.
Bom, eu só queria parabenizá-los pelo trabalho. É um prazer estar nesse treinamento com vocês. Conheço a Gil e a Nayara desde o ano passado, desde a evolução. E parabéns também para os novos membros que em poucos dias conseguiram fazer uma ótima apresentação.
Certo? Vocês podem ver que é uma preparação tão rigorosa que eles têm respostas para todas as perguntas. E quando não tiverem, eles se viram. E, para tanto, não tem como inventar uma resposta e não tem como prosseguir por achismos. É preciso realmente ter um trabalho de pesquisa e de estudo importantíssima, amontante, para poder chegar aqui com uma certa serenidade, uma tranquilidade e saber que, mesmo que eu não consiga antecipar a pergunta, a minha pesquisa foi feita de uma maneira tão consolidada que eu sei que eu tenho a bagagem suficiente para poder discutir com o tribunal e não deixar as perguntas ou o tom de voz um pouco mais bravo de um juiz me desmoronar aqui e me fazer completamente chorar. Certo? Então, eu espero que vocês tenham gostado do exercício. É algo que eu os recomendo para realmente fazer no futuro, quando tiverem tais competições. Lembrando que não temos apenas o Jessup, temos outras competições cuja língua franca é o português, sejam competições nacionais ou competições internacionais. Certo? Eu agradeço a todos pela participação. Obrigado.